All right, we are going to finish talking about the courts today, and we're going to look at the last topic, checking and balancing the federal courts. And this is a great political cartoon from right after the Citizens United decision, where Obama wasn't very happy. He publicly told that to the Supreme Court during the State of the Union address. And without getting into a lot of the details of that, I just like the cartoon because you have a great example of separation of powers, checks and balances between each of the three branches. All right, so if you've been with me throughout this unit, we've been looking at these essential questions, and in this short little video, we're going to focus on the essential question G. We're going to look at how the courts check and are checked by Congress and the President. More focused on how they are checked rather than how they do the checking. And then we're going to look at the relationship between the court and public opinion and how politics can play a little bit of a role when it comes to the federal judiciary. All right, checks and balances. So the president and bureaucracy, I kind of grouped them together here. And you probably already know some of the biggest checks that the president has on the courts. The biggest check is the ability to appoint the judges and justices on the federal courts. Now, I put in parentheses there, it's a short-term check because once that person's appointed and if they get confirmed by the Senate, you know, the president doesn't have any real power over the judge or justice anymore. However, by deciding who's going to be on the court, that's a huge, huge power. And then something we haven't talked too much about, but when the Supreme Court or the courts make a decision, they need the executive branch, including the bureaucracy, to enforce those decisions. And a great example of that is in the Worcester versus Georgia case of 1832. This is one of John Marshall's last decisions, and this is what led to the sad Trail of Tears incident, where the Cherokee Indians were not happy that the government, people were taking their land, and Marshall said that the government had no right to take the Native Americans' land, and Andrew Jackson pretty much just ignored it and told the Supreme Court, you've made your decision, now try to enforce it. And without the executive branch to follow through with court decisions, you know, the court doesn't have a police, it doesn't have an army to make sure that people follow through. The most power over the courts comes from Congress, and these are things we already know. Congress has the power to create federal courts. The only court mentioned in the Constitution is the Supreme Court. However, Article 3, it talks about how Congress can create lower courts, and they did that. Judiciary Act of 1789, you get the three-tier system we have with the district courts, the appellate courts, and then, of course, the Supreme Court. Congress can change the appellate jurisdiction of the courts. And then one of the interesting things, too, in history is the changing the number of justices on the court. It hasn't always been 9. And when FDR was president, he really pushed Congress to up the number over 9 because he wasn't happy with how the Supreme Court was striking down, judicially actively striking down a lot of the laws, the New Deal legislation that he was signing. Congress can always impeach judges. It's rare. The House would impeach, the Senate would conduct a trial, but it is a big check that Congress has on the courts. As you know, the Senate confirms any appointment. So when the president appoints, the Senate has that short-term power to confirm, and the Senate can, you know, they don't necessarily have to approve every presidential appointment. Just look at Mr. Bork from the 1980s. One of the interesting things, too, we've also looked at, and we looked at the history of this a couple days ago, was the history of the Lilly Ledbetter Fair Pay Act. This is one of the first laws, I think it was the first law President Obama signed when he took office. The Supreme Court made a decision that a lot of people weren't happy about, and it dealt with women suing for unfair pay from their employer. And what Congress did here was they can't overturn the Supreme Court decision, but they created a statute so that people in the future could be able to sue their employer and get a little bit more money than what Lilly Ledbetter was actually able to get. She was kind of like the sacrificial lamb, but her case was used as the proof that we needed to fix the fair pay laws in our country. And as you know, if you're not happy with a Supreme Court decision, the most powerful check is to create a constitutional amendment. But that is quite rare because you would need, you would need 2/3 of both chambers of Congress to approve. You would need 3/4 of the state legislatures to ratify, and well, that just doesn't happen very often. All right. The last thing I want to look at here is the idea of politics and how that plays a role in Supreme Court decisions. And so take a look here. This is a part of Justice Sandra Day O'Connor's opinion in the Planned Parenthood versus Casey decision of 1992. And this dealt with abortion, the ability of states to restrict abortion access. Pay attention to the italicized portion. And I italicized it to emphasize something. All right, here it says, the court's power lies rather in its legitimacy, a product of substance, and the perception that shows itself in the people's acceptance of the judiciary as fit to determine what the nation's law means and to declare what it demands. Thus, the court's legitimacy depends on making legally principled decisions under the circumstances in which their principled character is sufficiently plausible to be accepted by the nation. That last part, to be sufficiently plausible to be accepted by the nation. The court is going to make tough decisions. They might make decisions that many people don't like. But if you pay attention to this, it's very interesting. If the Supreme Court makes a decision that nearly everybody doesn't like, will people follow it? Will people give the court legitimacy? And that's what Sandra Day O'Connor is talking about here. The court has to be careful. Yes, they have the right and the ability, and they should make decisions that are tough and maybe not always popular. However, they still got to make sure that these decisions will be accepted, and, as we mentioned before, that the executive branch, whether it's at the national, state, or local level, will enforce the decision. All right, so let's talk more about political checks. How is the court affected? So we're going to look at how the court is affected, but we're also going to look at how the court is somewhat insulated by politics. Well, to get on the court, you have to be appointed, you have to be confirmed, and you have to please presidents, senators, linkage institutions. Just remember, you don't want to be borked. As we mentioned before, the Supreme Court, should and does make decisions that might not always be popular at the moment. Nevertheless, they need other institutions to enforce those decisions. So if they're making judicial decisions that aren't gonna get the support of other branches, what happens to the legitimacy of their power? New laws, amendments can overrule decisions, or the laws can kind of go around a decision, change the wording of statutes so that it makes a statute legal. Amendments, when you add an amendment, it becomes part of the Constitution, and then the Supreme Court has to use that in their decision making. And then, of course, justices can be impeached if they're really, if they do something illegal or something that, really deserves it. They're going to make decisions that might not be very pleasing, but, it's rare. It's rare that they're going to use the ultimate weapon against a judge, whether they're at the district, circuit, or Supreme Court level. And then one of the interesting things too is that over time you can have future courts alter the precedents made by earlier courts. So you look at Roe v. Wade, really controversial decision, stating that abortion is something that women have the liberty to do because of privacy concerns. A lot of people didn't like it at the time. Many people still, have their, negative feelings towards it. In 1992, the Planned Parenthood versus Casey ruling came in, good 20 years later, and it didn't overturn Roe v. Wade, but it did allow for the states to restrict, to make abortion access a little harder to get. So over time, the court can alter, limit previous precedents. So politics. On the other hand, the Supreme Court is also quite insulated from politics. And we talk about insulated, meaning protected. They don't have to worry about elections because they serve life terms. They get to decide their own docket of cases. The docket is the cases that they're going to hear from the appellate jurisdiction. If it's an original case, they have to hear it. But they get to decide. And they might pick something that might be really, really controversial. They might pick something that no one ever really knows about unless you follow the court. So at the same time, they are affected, but they do have a lot of protection from politics in order for them to make decisions that might not always be very pleasing when they're made. All right. My students, I'm gonna put a link up here for you to watch this video, and this is kind of cool. It comes from C-SPAN, and it just talks about why the Supreme Court is usually a little bit more detached from politics than the White House and the Congress. I'm gonna add a hyperlink here so you all can watch that. And that's it. I hope you enjoyed this video explaining how the Supreme Court is checked by the different institutions of government as well as by politics. Have a great day.